We'll get started, and the first thing on the agenda is a presentation by our Attorney General, Liz Murrill. And General Murrill, if you want to come to the table and give us your presentation on post-conviction relief, which is the subject we're trying to understand.
Thank you, Mr. Chairman and members of the committee, for allowing me to talk to you a little bit before we start this discussion about what the process is for post-conviction relief and for what I'll call repeatedly subsequent petitions for post-conviction relief, which is where most of these cases come up in our discussion. So I handed out a little diagram. And I'm going to reference that diagram because I want you to be able to see where the case starts in the criminal justice system and then where it goes after conviction through the appellate review process. And we'll just kind of walk through that pretty quickly. So every case starts with charges and a trial or guilty plea. And that entitles someone to a right to appeal on direct review. So that's the initial column that you see where they can take issues up and take them to the state court of appeal, First, Second, Third, Fourth, Fifth Circuit Courts of Appeal. Sometimes issues get up there during the trial, but this is going to be after the trial. And then they can go to the Supreme Court. And they can appeal the same issues that they brought up at the Court of Appeal in the Intermediate Court of Appeal. They can take up at the Louisiana Supreme Court. That's a supervisory relief court. So they may take the case. They may just affirm the judgments. They may deny the writ and say, Court of Appeal, you did a good job. They then have the opportunity at that point to go to the United States Supreme Court and file a cert petition on direct review. Again, that's discretionary at the United States Supreme Court. Most of those cases don't get relief. Sometimes they do, but most of them don't. After that, the defendant under state law is entitled to go through a process called state post-conviction relief. That's a process that the legislature has afforded defendants in the criminal justice system, but it's not legally required by federal constitutional law. We do that as a matter of legislative decision and legislative grace in the criminal justice system, where they can go back into the state system and raise certain issues on post-conviction relief. We call it state habeas. It's technically a civil proceeding. The person is challenging they're being held in a prison, and they're challenging usually certain constitutional issues that they think were defects in the proceeding. That may be where they're bringing up ineffective assistance of counsel, usually in that stage, because you wouldn't be able to do it before that. So that process starts all over again. You file it in district court. The judge makes a ruling. You can take it up to the Court of Appeal, and then you can take it up again to the Louisiana Supreme Court. Those cases don't go to the United States Supreme Court. They just, at that point, you can go to federal court, and you have a right to federal habeas. So now you can file your appeal in the federal court and raise questions of federal constitutional law in federal court. In both of these proceedings, in state habeas or in federal habeas, there are procedural restrictions. There are limits in the law in terms of the time that you have to bring the petition and the claims that you can bring. So that's all on the state post-conviction relief, a product of, it's all in the state code of criminal procedure. In federal law, it's matter of federal law. A lot of federal habeas law is jurisprudential. So a lot of that happens in the courts, district courts. So they'll file a petition there, and then they can ask, they have certain ability to seek relief in the United States Fifth Circuit Court of Appeal, and then they can go back up to the United States Supreme Court in federal habeas. Federal habeas is very limited. There's a federal statute that requires requires deference to be given to state judicial decisions that have been made on issues that were raised already. So there's some deference given to that judicial review at the state level under a federal statute that applies once they're in that stage of the proceeding. After that, they have the ability to go to the governor and seek clemency through the Board of Pardons or a commutation of the sentence. So that is really sort of the whole process that somebody that's been convicted of a crime in our criminal justice system. That's the path that they can take, and that I think kind of illustrates how many judges they're going to see in that process in that first round. So we also have a statute that allows for subsequent petitions for post-conviction relief. So what we're really going to be talking about today are predominantly convictions that are being revisited in a subsequent petition for post-conviction relief. In some cases, it's the third. It may even be a third petition because we don't have a limit on the number of times that you can file a repetitive petition for post-conviction relief. But we do have pretty strict limits on what the basis for relief is for a subsequent petition for post-conviction relief. And I can, I have a few cases. I know that, and I've made public statements that I'm going back and looking at a number of the cases that occurred in Orleans Parish because there's a disproportionately higher number of cases that have been granted relief in Orleans Parish, substantially higher compared to every other district attorney in the state. And so when that discussion arose, I said I want to see exactly what's happening in these cases. So I've taken the cases from January to July. I picked January because that's when I got inaugurated. So I'm going from January to July 31st when we changed the law. So you did make a change in the law in the criminal session, and that change affects subsequent petitions for post-conviction relief. It clarifies that the restrictions on that petition are jurisdictional, that they limit the court, and that the court has to look and make sure that these restrictions have been met when that petition is filed, and that those are not waivable by the district attorney. So that places some responsibility in the hands of the court to ensure that the restrictions that the legislature put in the statute are met. And it also allows the Attorney General, requires service on the Attorney General of the initial petition, and it allows me to intervene, or any Attorney General to intervene if they believe that that is appropriate under the circumstances, and defend the conviction. And so what I'm doing now is I'm taking a look at all of those cases where relief was granted by a court in a case where there were no procedural objections asserted. So it's been my opinion that the restrictions in the statute are jurisdictional, but there are some that are considered procedural, and the statute, quite frankly, doesn't say which is which. It does now. It says that all the restrictions in subsequent petitions for post-conviction relief are jurisdictional. So that was a good clarification, I believe, that occurred in the law. There's a lot of testimony about it. I can tell you that in a case that involves actual innocence, those restrictions don't apply. You can always bring that case where it involves a claim of actual innocence. So I think that the restrictions that we brought, that the changes that you made are important changes that have occurred, but you do I think it's going to be a good process that we go through to kind of look at what's happening in these cases so that you understand better what occurs in all of these cases and why that was an important change to the law, and can consider any additional ones that you might want to make. And I'll take any questions that you have.
Thank you, Attorney General Murrill. A quick question for you. Out of the cases that you've reviewed thus far, and we've reviewed and our staff has reviewed some of the same cases, and there's been a little bit of a delay getting documents and all that, but our findings thus far, out of close to 40 cases, there was only one in which it was asserted that there was factual innocence of the defendant. is that your understanding, or have you reached a different conclusion, or are you still working your way through it?
I'm still working my way through it, so I'm certainly not in a position to agree or disagree with that conclusion.
That's thus far, but
I mean, I can
that's our
tell you that a
finding.
lot of these cases are not actual innocence cases. There are a number that I've seen through my initial review where they are cases that have been fully adjudicated and reviewed. In some cases, they've already been through a second petition for post-conviction relief, so you may be on a third time. And so that's part of what I'm looking at. I'm looking at whether there was, in my opinion, right? I mean, I'm looking at this and reviewing the work and the decisions that somebody else made. But I'm looking at whether I think that there was a legitimate claim made and briefed for, say, you'll see some are Brady claims. Some have additional claims regarding non-unanimous jury verdicts. And I can tell you that if those cases were on direct review, then that defendant obtained relief through federal constitutional law. But post-conviction relief was foreclosed by the state Supreme Court and by the United States Supreme Court when it denied retroactivity of the Ramos case. So that would not be a legal basis for relief. And if there was a policy decision made by the district attorney that he didn't agree with that decision, then I'm going to make a note of that. So my position is the district attorney, the job is to enforce the law and not make the law. And so if the district attorney had a disagreement regarding legal policy, that's not a basis for relief. If the district attorney has a judgment call to make about the evidence and the strength of the evidence, I think that, that is part of the discretion that's granted to the district attorney. But once you've been through multiple reviews by a judge, by courts, by multiple courts on those same claims, now you are undermining the decision, not just of the earlier person who stood in your shoes as a district attorney, but of every judge and every court that has reviewed that case.
And the jury.
And the jury. I mean, the jury made a determination on guilt or innocence. The jury may not have made a decision on some of these evidentiary questions or constitutional objections that were made, and they may have come after that jury was long released.
And a number of these cases were guilty pleas.
Some of them might have been, yeah.
In any event, Senator Abraham has a question.
Thank you, Mr. Chairman. I'll try to keep it brief. I don't want to get too much in the weeds. I'm one of the non-lawyers up here. So you mentioned, I just wanted some clarification on what you said on the new law. You said the court has to determine, I guess, whether they get post-conviction relief. As I understood it, you said it used to be procedural, now it's jurisdictional. Is that correct?
So there's language in the statutes that refer to procedural objections.
And what does that mean, procedural?
It's not really defined in the law, and I think that's part of where there's some confusion. There are restrictions in the statutes on the basis for bringing a petition for post-conviction relief and the timeline for doing it. So, for example, you're supposed to bring it in a year. Now, we can have a whole separate discussion about some legislation regarding the timeliness of those petitions, because they frequently go on for they sit for a very long time, and that's because people file something called a shell petition, and then the shell petition sits around for years, sometimes before an actual substantive petition is filed and a decision is made by the court. But what usually happens in these cases is the district attorney asserts procedural objections and then doesn't have to do anything until a judge rules on those procedural objections.
The judge still has to rule, though.
The judge is supposed to rule on those. Now, if you waive them, there's nothing for the judge to rule on. And so waiving procedural objections is something that I focused on, particularly when it came to these subsequent petitions for post-conviction relief. Because remember, you've already gone through all of this when you're on a subsequent petition for post-conviction relief. So you made it clear in the law that the restrictions for a court to entertain a subsequent petition for post-conviction relief are jurisdictional. That means that it gives,
that
it
law
makes the
takes-
judgment null if they
But
grant
that law
it
takes
without.
effect when? When did that law take effect? The jurisdictional.
August 1st.
August 1st. So we're
Right.
talking about, that was not the law in the time frame you're referring to right now. Is that correct? The January through
it
July.
didn't say, it
It's
did
not
not
as
say
clear,
those
I guess
things.
I should say.
Correct.
And that's where the procedural part was coming in January through July, or whatever, and now we're on the jurisdictional side as of August 1st. Now, on the jurisdictional, that means that the court has to intervene or has to make a decision, right?
It places a burden on the court, on the judge, to ensure that those restrictions in the statute have been met. And when you say that there's a jurisdictional restriction on the court, it means the court doesn't have the power to entertain that petition unless those conditions are met. So it would go to the actual judgment and the ability of that judgment to have any legal effect in the event that the judge did not check those boxes.
Okay, so what we're really talking about here is the fuzziness of the procedural side that didn't really have court input, I guess, in a sense. Is that right?
I think that was part of it. I mean, the other part of it was if a district attorney was able to, went into court, as happened with a number of these cases, and conceded the merits or conceded the procedural, did not assert those procedural limits, there was no one to check that. There was nobody to come in and argue or defend the conviction. And so that's why I asked that the Attorney General receive service and the ability to intervene in those cases, because what we have is an adversarial system. It contemplates that someone will defend the conviction. Now, that's not to say that there could be cases where there's a legitimate, I mean, there are cases where there are legitimate claims, but remember, these are cases that have received a substantial amount of review by courts at this stage. And so it is important, I think, at that point, that we defend the conviction. And what we're seeing is 15 and 20 years later, sometimes 30 years later, someone's come in, a district attorney's come in and said, I'm going to waive procedural objections, I'm going to concede the merits, and we're just going to vacate the conviction and redo it all.
As a general rule, it's fair to say that the district attorney usually fights to defend the conviction his office obtained. As a general rule, it's adversarial. So, but what you're saying now is an inordinate number of cases. The DA saying we're on the side of the criminal defendant, and we're agreeing with what they're saying in their post-conviction relief motions or documents, and a judge signs an order, and then it's done without your being even notified. But for this new law that went into effect August 1st. Now they have
Correct.
to notify
I wouldn't have
you.
been noticed. I wouldn't have received notice of it before that.
Right, before August 1st.
The Department of Corrections receives notice because they have custody of the person. And so if they are in the custody of the state and state prison, then they get a notice. But the Attorney General didn't get a notice. And so now I have an express right to intervene and defend the conviction. I mean, I think that, the only caveat that I would say to your description is that every district attorney, I think, would also agree, and all of us would agree, that it is their job to do justice and that they should look at that petition and see whether there is a legitimate claim. But they should also do that in light of the prior history and the prior decisions that have been made by the courts to review those same claims. And whether, whether that district attorney is now stepping into the shoes of the governor and trying to basically concede an error that has been denied over and over and over again by the courts, that's where I would have a concern. But it is important for the district attorney to give us, to look at that petition and make the right decision.
Yeah, I'm good. That was a very good explanation. That's why I just want to clarify, zero in really what the heart of the matter is, and I think you've explained it very well. So thank you.
Thank you, Senator Abraham. Senator Miguez for a question.
Thank you, Mr. Chairman. Senator Abraham asked a number of the questions that I had, so I'm trying to clean up any gaps in the testimony. So As it relates to, it seems like you touched on the point about the AG's involvement prior. There was no notice to you as a notice of corrections. Now you have it's required for this type of action to move forward. You have to be given notice and you have a right to intervene, correct? Is there any other powers that the new statute provides to the Attorney General in this process?
Service on the Attorney General and the right to intervene in a subsequent petition for post-conviction relief. That's it.
We talked about the procedural aspects, jurisdictional aspects. Would you say that the district attorney still maintains discretion after this new law is put in place and more of the burden is put on the judges? How do you manage? How would you say that is now?
I mean, I think, in any one of these cases, the initial burden is on the defendant who's been convicted to make the case that they are entitled to relief. So, when I look at these cases, when I'm conducting my review of the 40-odd cases that I'm looking at from January to July, I am looking to see what evidence was presented to the courts that wasn't already adjudicated previously by a court. And that's where I would say you probably fall more into a discretionary place where the district attorney has to really look at that and see, because that may be new evidence. But if it's already been adjudicated, then I'll have a column where I mark that that issue was decided by courts before it ever came up again in another subsequent petition for relief. So I'm not sure if that answers your question.
On the procedural side of things and the timelines, not to get too far down into the weeds, but your testimony was that the new legislation August 1st sort of cleaned up some of that fuzziness. Do you think there's any more improvements that can be done there to tighten up this process?
I do.
Any suggestions for the committee at this point in time?
I think I'd probably rather bring those to y'all in a comprehensive package, because there are a large number of statutes that walk through post-conviction relief. Issues come up in those proceedings that are kind of different, but you do see some common ones, and so I think there's some things that you could do. I'll make those recommendations.
If this committee and the legislature finds that what may have been happening prior to the August 1st legislation going into effect is an issue and a problem here in Louisiana, it seems like the August 1st changes may have not fully addressed those issues, and we can make further changes to improve the current law. That'd be your testimony here today.
Yeah, I do think there are some changes that we can make going forward. Yeah.
Now, tell me an idea of these. You went through the whole scenarios of all the different relief that someone who's been convicted can go through. You went through all that in your outline, and we get into post-conviction relief. Tell me how often this happens, like in a jurisdiction. Is this something that happens? You see one very seldom, or this happens in a multitude across the entire state?
Well, petitions for post-conviction relief are frequently filed.
Okay.
I mean, they start that process with the first round of PCR after a conviction.
How often are they granted?
That's the first round, almost every time. So, unless they've pleaded and given up their right to appeal, then they're usually, as a matter of course, going to file for direct review, and then they're going to come back and file state post-conviction relief.
Subsequent
they don't get that relief in most cases.
Okay, that was my question.
In most cases, it's denied, and in most cases, the district attorney comes in and immediately, as a matter of course, files procedural objections. And by filing procedural objections, the district attorney doesn't have to do anything else until the court rules on those procedural objections. And I mentioned these things called shell petitions. Those can take years sometimes. I mean, limiting the amount of time that a shell petition can sit would probably be a good change to the law, because right now I don't think there is a time limit on that, and you can sit for 10 years and have a shell petition and then come back later and fill out that shell petition, and now all of a sudden you're dealing with claims that are 10 years old, with witnesses who may no longer be available. It is substantially more difficult to deal with a problem where relief is granted when the petition has not been addressed for that period of time.
But like in one of these jurisdictions, you'd say that happens where the relief is granted once a year, 10 times a year, 50 times a year in a parish?
I couldn't tell you that statute. I mean, that statistic, I really don't know. It is much different. I mean, the numbers in New Orleans are substantially different than the ones for other district attorneys around the state by a matter of hundreds.
Wow.
Madam
So-
Attorney General, you have a couple of people at the table, one of whom I spoke with as we were walking in the door, who could shed a little bit of light on that. If your colleagues could introduce themselves briefly. You don't have to leave the table.
Just sitting
We're
back.
going to have some more questions here.
Yes, thank you, Senator Morris. My name is Allison Rutson. I'm here on behalf of Hiller Moore from East Baton Rouge Parish. I'm in our appellate division. I've been there since 2008. I think I can answer some of your specifics, Senator. As far as the granting of PCR, that happens very rarely. We may have had maybe 1 to 3 grants in the last 5 years.
The last 5 years?
Yes.
Has
Now, this is
has the
state
number?
post-conviction. The habeas numbers might be a little more, and if we're factoring capital cases in, that might factor, but.
So you've had 1 to 3 in the last 5 years?
From the court.
From the court?
Yes.
Where they've granted it, right?
Where they granted relief.
Is there anything that changed in the judicial systems, maybe since May, between May and August, which would in turn have more of these granted?
No, Your Honor, excuse me, I'm used to.
That's
arguing to the Supreme Court of
Senator
Louisiana.
Abraham. I'm Senator Miguez.
That's a typical mistake of a lawyer, so
All right,
just
first
excuse.
timer, can you tell? Nothing has changed. Our office is a little different. We have a lot of post-conviction applications. We probably get at least 100 filed per year. And
Has there been an increase because of the new law coming into play in August 1st? More requests? Anything that would have changed in the process to
we've
why
not seen
you'd
those.
have
We are not waiving. We've never waived procedural objections in EBR. So we've always asserted those when we can. In fact, when I train new attorneys, I always tell them to go look at the procedural stuff first. And the procedural is just different in that it's different from the merits. The merits actually get to the heart of the claim. A lot of times, those are easier to address because a lot of them are meritless. The procedure can sometimes, as we've seen today, you really do get into the weeds talking about procedure, but we always like to go with procedure first in EBR. So I can't speak to what other parishes are doing.
And tell me the main reason why you don't have more than 1 to 3 in the last 5 years. What's the reason for that? That are granted, mainly.
Our courts do like to afford the finality of conviction that comes with a conviction. They're supposed to be final. We get a lot of applications filed in conjunction with pleas. Sometimes pleas can be a little more problematic if a judge messes up or if an attorney hasn't advised. There are some changes in the law that do trickle down as far as a counsel's effectiveness and what is required of defense counsel at each different stage of the proceedings. It used to be in Louisiana that you weren't entitled to effective assistance of counsel at sentencing. Now that has changed in the last 5 years with the Harris case, so we do have to fight some of those cases. That is a battle with us that once you get a case out of the Louisiana Supreme Court, or definitely the feds, it applies to all of us. And so we have to look at that application going forward. Because, of course, defense attorneys are, they are good at what they do, and they try to expand the application of that case, whether we think it's very narrow or it should be applied narrowly. They like to widen it, and so that makes our decisions.
If you could speak on behalf of District Attorney Hiller Moore, would you say your main mission statement is, as being a district attorney, would you say public safety is number one?
Absolutely. Public safety and doing justice. And there have been cases. We absolutely believe in our juries, and we believe in our system and our processes and the checks and balances that are in place.
Public safety is number one, right?
Public safety, absolutely.
And how do you keep public safety here in Louisiana? Is by keeping criminals off the street. Would you agree?
Absolutely. Violent criminals, especially crimes of violence, have to be our focus.
We do have constitutional rights, and there's a process the Attorney General laid out in the event that the criminal justice system potentially got it wrong, right? Before we ever get to the conversation that we're here today for.
Absolutely.
And it's pretty extensive. Deals with a lot of judges, a lot of input to make sure that that decision was correct.
Many eyeballs are looking at that conviction from the time someone either pleads or a jury convicts that person. You have 3 judges at the appellate court. You have, in EBR, we have a non-elected commissioner. So we have a commissioner and a district court judge. Then you have 3 more judges at the appellate court. then you have 7, 8 judges at the Louisiana Supreme Court. So by the time someone has been relegated to the post-conviction collateral review proceeding, you've had at least 10 to 12 eyeballs looking at that, in addition to the jury.
So
Convicted
when a
them.
violent criminal goes through this entire process, this whole process on the page, and exhausted this, there's a great chance that you guys got it right. The very, very seldom that you didn't get it right based on the numbers you gave me earlier, if you only are granted 1 to 3 every 5 years. Now, are those, you're a pretty big jurisdiction. Is those numbers similar across the state with other jurisdictions?
I can't speak to the other jurisdictions. I can only speak to EBR.
And you are one of the 5 largest?
5,
The largest would be what, Caddo, Lafayette,
Jefferson
EBR,
Parish, we are one of the
Jefferson, and
biggest.
Orleans,
Yes.
I would say, roughly. Okay, thank you so much. I appreciate it.
Thank you, Senator Miguel. Senator Duplessis for a question.
Thank you, Chairman. First, I want to thank you and the Senate President for allowing me to be a part of this hearing this morning, and thank you, AG Murrill, and your colleagues for being here. I just have a few questions, and I guess the first would just kind of be a little bit foundational in terms of how we got here today. So I would like to just kind of begin with what prompted this meeting, what led to us being here today. Yes.
But do you want me to speak to that?
Yes, please.
I mean, I can tell you that I think there were questions that were being raised
By who?
In the public. I mean, I saw different people raising these issues.
Can you just
I've had
be
discussions
specific?
with other district attorneys. I mean, I
Okay.
started looking at some of these cases, but I mean, I think that questions have been raised for several years now, not just in the last few months. That's what prompted me to suggest some of those changes that we made in the law in February. But I had discussions 3 years ago with District Attorney Williams, and I want to say I've worked well with Jason Williams on a number of things. We have some differences of opinion about post-conviction relief, but this has started. I think more questions have been raised recently because there appeared to be more cases being pushed through in the last few months. Now, I can't tell you whether that's true or not. I really can't. I can tell you that I went and got the list of cases, and I am going through the list of cases to try and verify whether there were cases that were trying to be rammed through before I had a chance through the Attorney General's office to have an opportunity to intervene and challenge some of these,
Okay.
or at least have second eyes on them, somebody having some outside eyes.
So that information has been provided to you. The DA's office has been forthcoming with all the information you've requested.
They have given me a large couple of binders of information. I've shared that information with others, and they have indicated they'll give me any other information that I ask for.
Okay, so we've been having a lot of conversation and discussions around post-conviction, which I think all of us would agree, whether you're an attorney or not, that post-conviction is a pretty specialized area of the law. It's not something you learn in first-year law school, second-year law school, or even third-year law school. And most attorneys are not even familiar with the area of post-conviction law. And you have some attorneys next to you that do this work, but it's a specialized area of the law, is it not?
It is, and they do
Right.
teach it in law school, but you have to elect into
Yeah,
it. And
but
I
it's not
took it and
something that
didn't
you're
understand
guaranteed to
it. So you can, I think everybody who does this kind of work would agree that it is specialized work, and that most lawyers really don't do this kind of work.
So we had a lot of debate on Act 10 that was passed in the special legislative session on crime that you mentioned earlier, but we had it in Jude B. Why are we in Jude C today?
Couldn't.
Because I called the meeting.
Okay, all right. And you, Mr. Chairman, you had a bill, I remember, in Jude B, too, that also dealt with DAs in particular. That was also in Jude B. So I'm just, again, curious as to why we're in Jude C today, because we've always had this
It's
debate
typical,
around
yeah.
post-conviction or dealing with prosecutors in Jude B. So I'm just curious, just a question, but you as the chairman have that discretion.
A, B, and C don't have defined.
Well, I'm just looking at custom.
Historically, yes, we
I'm
do
just looking
handle
at
most of the
custom.
criminal matters, but.
Because we had extensive debate around Act 10 that was passed during the crime session and some of the concerns there. And I raised questions and concerns, particularly as it relates to the issue of prosecutorial discretion. You had members from your staff who were there who sat at the table and asked certain questions. I want to go to the most recent Supreme Court ruling on this that you actually just cited. I believe it's the Lee case that talked about retroactivity or the lack thereof as it relates to non-unanimous juries, the non-unanimous jury decisions. And I want to read a portion of the holding that clearly states, and I'm just asking if you disagree with any of this, that if a defendant seeks post-conviction relief, a district attorney is now required to oppose the application. For example, if a defendant claims his conviction was obtained in violation of the Constitution because he was denied effective assistance of counsel, or because the state withheld evidence under Brady, in violation of Brady, the DA may choose not to raise procedural objections even when they apply. Furthermore, and this is the most important part, the district attorney has absolute discretion under the Louisiana Constitution, Article 5, Section 26, and the Louisiana Code of Criminal Procedure to not oppose or even join an application for post-conviction relief that raises a cognizable claim for relief. The broad authority is necessary because a prosecutor's responsibility is as a minister of justice, not simply that of an advocate. So going to the issue of prosecutorial discretion and the discretion that was exercised by D.A. Williams or any DA across the state, because it's my understanding this isn't the first time this has been done, maybe at the volume, but did that case at all speak to the amount of negotiations that could be entered into or agreements that could be entered into by a DA, then signed off by a judge? Did it speak to any issue of the amount? Is there a limit?
No, it didn't. But let me say this. I believe you are quoting from Justice Weimer's statements in that case, and I don't entirely agree with the blanket statements that were made in that case. Post-conviction relief is a creature of state law. You are not even legally, constitutionally required to provide it. So it is entirely a process that has been created by the state legislature to offer another avenue of relief.
Does state law require the DA to oppose an application for post-conviction relief?
It does now on subsequent petitions for post-conviction relief, and I believe that is entirely within the discretion of the legislature to create.
So was anything done by D.A. Williams that was in violation of the law then or now?
I can't tell you that yet because I'm looking at every case individually. And what I am looking at, to be very clear, is whether those cases involved decisions by the district attorney that really amounted to a disagreement on criminal justice policy.
It's a policy decision.
A policy decision, because in a lot of these cases, as you point out, they have gone through subsequent post-conviction relief. They've gone through the first round. They've gone through the federal round. In some cases, they've come back and gone through another second round, and they're on their third round. So, you are, in some of these cases, substituting your judgment for that of not only the jury, but the judge who gave the sentence, the legislature who established what those sentences should be or the range of sentencing for certain crimes, and then subsequent courts that have reviewed those sentences and determined that there is no legal error and that it was appropriate. So that's what I'm looking for, and I think that I'll come back and tell you what I find.
Sure.
But I've already found in some cases.
But ultimately, since we already acknowledge that no matter what, it will boil down to a difference in viewpoint from a policy standpoint. So when you say what your findings are,
but it's it is not the job of the district attorney to disagree with the legislature, the judge, and the jury on the criminal justice policy.
But any of those decisions still have to be signed off by a judge, do they not? Can the DA just make the decision on his or her own without the judge signing off?
In front of a judge.
So the judge still has to sign off on it.
But if there's no one objecting, and if they have completely conceded on the merits, there's no one. What is a judge to do when the district attorney is not actually adjudicating?
But that's still within the law.
I didn't say it wasn't within the law. I said there's no adversarial in the system at that point, and so a judge is not going to advocate in the system.
Okay.
And that's one of the reasons why I asked for the change on subsequent petitions for post-conviction relief, because if it is a matter of policy, then I believe somebody ought to be in that system defending the conviction.
So you got the change that you sought in the law during the crime session. So why are we here today?
Because we're looking at, I guess, what's happened in a number of these cases.
I think that will explain itself as we go through, because I called this.
Okay,
in response.
So we got the change in the law. So I'll ask you, Mr. Chairman, we got the change in the law, so why are we here today?
To determine whether or not what has happened thus far deserves a policy adjustment in the future. I think Attorney General Murrill has already said that she thinks that next year we probably should change the law a bit more. And so,
But the law just took effect August 1st.
right, but she's suggesting there might be other changes, and as we go through this process, and by the way, this is not going to be the first hearing on this. We're going to have more. We're at the preliminary fact-finding stage, and we'll be going through some of the cases that cause a lot of concern by members of the public. And we can get into those weeds in a bit.
I'd like to go there just a little bit, talking about members of the public, because we have locally elected DAs. We have DAs from all across this state. We have an elected AG. And the people we elect reflect the values and reflect the policies that the people of that area want to see in the people that they elect. So this question of the democratic process and who we elect or don't elect based on the values of that local electorate should be reflected in the people that they elect. Do you not agree with that?
I mean, I think you're making very general statements. I don't think that we
It's a
elect
clear
people to
statement.
nullify the law.
Okay, let me ask you this question. This is straight from the core values of the LDA, the Louisiana District Attorneys Association. I just want to ask how you feel about it. Louisiana District Attorneys Association clearly states that we believe that the Louisiana Constitution requires and Louisiana citizens favor locally elected independent prosecutors. We believe that prosecutor discretion must be protected from interference through manipulative funding or legislative restrictions. Finally, we believe that prosecutors are the best and most trustworthy resource for legislative improvements to the criminal justice system. Do you not believe that this hearing that we're having today and this effort is in some way an overreach to DA discretion or in some violation of the spirit of the core values of the District Attorneys Association for independence for DAs?
Hey, look, I support the DAs. I work closely with the DAs. I assist the DAs in prosecuting cases, and I take their recusals. I am, in effect, a DA in that sense. I stand in their shoes when I take cases that they can't handle, or for whatever reason, not that they can't handle them, that they were recused from. I think they do a great job. I think we have great DAs. They are elected, and I respect that part of our process.
So every time
there's
there's a
nothing wrong with
difference-
the legislative oversight hearing.
So every time there's a difference in a policy decision that's made by a local DA, we're going to have a Senate hearing, change the law based on someone who's been duly elected. That's why we have elections, do we not? That's why New Orleans. That's why the city of New Orleans went in a different
We're getting
direction.
kind of beyond the
Senator,
scope, and
we're
we're
not.
talking in platitudes now.
Yeah.
No, I'm not talking in platitudes. I'm just asking a question.
I understand your question, but we can't take up the whole hearing, you guys bantering back and forth over the 50,000 level. We need to move forward. I would ask Senator Duplessis to just ask some specific questions about the facts before us or the facts we want to get out today, so we can get to all that. We have witnesses at the table who hadn't even had a chance to speak yet, and I've got members who need to leave. They can't stay into the afternoon, so I do want to try to get through this meeting where everybody has a chance.
I respect that, Mr. Chairman, and again, I appreciate you for letting me be a part of this hearing today. But I think these questions are important. And I want to be clear, I'm not here to defend the district attorney. D.A. Williams is fully capable of defending himself, and I'm sure he's going to have the opportunity to speak on behalf of his office and his policy decisions. I'm here to defend the process and what's going on here today. And on behalf of the people of New Orleans, I believe that the people of New Orleans, with a nearly 60% vote, made a decision in 2020 to go in a certain direction based on certain policy promises that were made. So these are not platitudes.
Well,
we're talking about policy decisions
And
that
respectfully,
the city
Senator
of New
Plessy,
Orleans
I don't think
made.
the victims of some of these crimes would agree with you. I mean, we have criminal justice system. I'm here too to talk about process. And when you have settled convictions, our process contemplates finality in that system.
But
and what we are
is there
talking
any
about are
violation of the law that took place, AG?
But some of these aren't violations of the law. I mean, that's my whole point. That's what I'm looking at. Was there an actual violation of the law? If that's been adjudicated already by a court multiple times, and that court has found that there is no violation of the law, now you are talking about one person who has come in and substituted her judgment or his judgment for that of all of these people in the system, including the jury. And that's what we need to take a look at. I think that...
Okay. Are there any instances of these negotiations or these agreements that took place prior to the Williams administration in Orleans Parish?
I'm sure that every district attorney has these cases that come up.
That's a yes.
Yes, but
Right.
I don't think anybody has several hundred of them.
Right. But again, going back to the law, going back to the Supreme Court ruling, there was never any restriction that was specifically put on the DA discretion in terms of volume.
I don't think that's a fair description of the whole system. The system contemplates an adversarial system where the district attorney is the prosecutor.
So it's
not
okay
the
if they do
defense
less than
attorney.
10, but it's not okay if they do more than 25? Like, what's the range to where it starts to get to a point of concern for you?
Every case has to be looked at on its own merits, but I mean, I think that you'll see from the flat numbers that the system is set up to favor finality of convictions and not to have revisiting convictions 15 and 20 years later because of a difference of opinion in criminal policy rather than actual legal grounds for relief.
Okay. I'll bring my questions to a close, at least for your presentation, and I'll kind of end it going back to a point that Senator Miguez was referring to, and that's on the issue of public safety. Has District Attorney Williams been a willing partner in working with you and the governor to deal with public safety in the city of New Orleans?
He's been very cooperative with me, I'll say that. Yes.
Okay. Have we seen a significant reduction in crime in the city of New Orleans?
We have, since we brought more troops into New Orleans and we increased prosecutions
Okay.
there. I think there's been a substantial decrease.
Okay, thank you.
Thank you, Senator Plessis. I see the board is clear. There's another gentleman at the table. I don't know if you want to speak. If you do, please introduce yourself and let us know.
Good morning, Senator Morris. I don't have anything to say unless there's specific questions for me, but my name is Taylor Gray, and I'm the Chief of Criminal Appeals for the Attorney General's Office.
Very good. Just as an aside, I've got a criminal defense lawyer in my family, I think I mentioned. I have an assistant DA in my family. I'm a lawyer, obviously not a criminal lawyer. And as an elected official for the last 13 years, I get letters from inmates from time to time. Everybody is innocent if you ask them. And everybody that gets convicted says their lawyer didn't do a good enough job. Is that a fair statement?
That is an absolutely fair statement.
And so it's incumbent upon you as a assistant district attorney and the other district attorneys in the room to pour through those assertions and determine whether there are any merits. And in large part, what I'm hearing is that most convictions are valid, and you don't have a problem going forward.
The large part, yes, sir. Mr. Moore asked me to pull our stats in East Baton Rouge Parish, and since 2005, I'm aware of 4 plea deals that we have made post-conviction, and in each one of those cases, there was an active post-conviction application filed, and there was an issue, either a discovery issue, or an evidentiary issue or intervening case law that impacted our ability to go forward. So there are, and they're all sad situations.
And with respect to prosecutorial discretion, they have that because our Constitution and our laws give it to them. It's not inherent. That can be altered by changing the Constitution or by the laws, correct? Madam
Senator
Secretary.
Morris, I would just say that prosecutorial discretion doesn't mean absolute discretion to rewrite the law. I mean, the law is already written. The district attorney is applying the law, enforcing the law, and then defending the conviction. So, and it does change. Once you're convicted, before you're convicted, the presumption of innocence attaches. Once you're convicted, then there is a presumption that those proceedings were handled properly, and so it changes. But again, I mean, I think that it's built as a system that is built around our job as prosecutors to enforce the law.
And as a legislature, if we believe that public safety is endangered because of the activities, and I'm not saying there it is or isn't, but we have concerns, it's fully within the right of the legislature to address that situation by a policy response. Would you agree?
I mean, I agree, and I mean, in the context of post-conviction relief, I'll take you back to what I started with, and that is that it is entirely a creature of this legislature.
We could repeal post-conviction relief.
You could,
Totally.
and I'm not here to tell you to do that.
Well, I'm not suggesting we should, but we
created.
But we could. We create it. We could take it away. We can't take away federal habeas corpus writs, and I wouldn't want to. There's always going to be a means to protect people who are factually innocent. But thank you for your testimony. The board was clear. Senator Cloud now has a question.
Thank you, Mr. Chair. For somebody who is not a criminal defense attorney, not a lawyer, I don't do what you all do. I am a citizen, and I am a lawmaker. Walking us through this chart, and I wasn't going to speak about this, but walking us through this chart and the realization of how many opportunities for review, how many levels and how many sets of eyes that are looking at the merits of an appeal. And knowing now, learning through this, that multiple opportunities with multiple sets of eyes at multiple levels, and still in all, at the end of the day, our state law does provide for one person to override all of this review, all of these sets of eyes, all of the fact-finding over all of the years, that one person can do that unilaterally with their own discretion, and to think that we shouldn't question it as lawmakers, as a society, if we're all crying out for changes in our criminal climate
I'm going to let these people go.
in Louisiana, and yet we're not going to look at this. I mean, I think that this is incredibly healthy, and I think that we should be here today, and we should have more of these in the future, because it provides a level of accountability. If there are loopholes and errors in our law, in our system, we need to have that discussion. We can't make all of these changes, spend all of this time on criminal justice reforms that we have been over the last several months, and then have this one opportunity to nullify all of the work that we've done for a safer Louisiana. So I think this is incredibly healthy, and I really appreciate the opportunity to learn about all of this.
Thank you, Senator Cloud. And I would just add one thing before I step away from the table, just kind of to your point, Senator Duplessis, about the discretion of the prosecutor. There's another Supreme Court case that I think is relevant to this discussion, and it relates to a statute that was recently declared unconstitutional by the Louisiana Supreme Court, because it did place greater discretion in the hands of a judge, a defense attorney, and the district attorney by consent to grant relief, and the Supreme Court said that was an unconstitutional violation of the governor's clemency powers. So, on the far side of that chart is the governor's power, which is also in the Constitution, and that's at the always inherent in the process, where the governor has the ability to convert, grant clemency, or reduce the sentence.